suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
It's time to talk law with David Whiting, Melbourne solicitor, to take your questions, 1300 222 774. If you have one, David Whiting, slightly later than usual, but welcome into the studio.
Thank you very much, Warren.
We didn't have any homework for you.
No, we didn't. But there's the one thing I would like to flag is a change to defamation laws that came in July came in earlier this year, but what we're now doing is seeing the cases are starting to appear in the court. Now, defamation is an interesting area of law because you start with an assertion that my reputation has been damaged as a result of what's been said or written, and I am now seeking compensation. At which stage the burden shifts to the person who makes the statement or spreads the statement, and they virtually have to prove that either your reputation has no value or that the statement wasn't defamatory. There's now a requirement that there needs to be an assertion that needs to be established to the satisfaction of the judge that serious harm has either has happened or will happen or is likely to happen as a consequence of the statement. And the aim is to, if you like, remove a whole lot of neighbourhood-type disputes from defamation.
So will it make it harder to win a defamation case in Australia?
It will make it harder. It will make it less likely that people will start a defamation case. So will it make it harder to win? I think logically it will, but it's if you think of it in terms of, say, a personal injury action where you've got to wear the first 10% of any loss of capacity, we're now at the point where, well, it's kind of like, have I met the threshold to commence a defamation?
David Whiting's with you. Just on that before I go then, does that leave defamation and that court action really as a realm for the rich? Is it really going to stop the people who don't have the resources to be able to take those actions?
Well, I think, part of the problem with litigation is whoever wrote the laws assumes that there is a degree of resilience in the community and there's a little bit of rough and tumble, a little bit of give and take. And there's a whole lot of very sensitive people who believe that my rights have been infringed, I want compensation. Now they've got to come along and say, if it's a defamation action, that there's been serious harm to my reputation.
Well, that's my go. 1300 222 774 if you want to have your say. Let's go to Tom in Ferntree Gully. Tom, you're speaking with David Whiting.
Hi, good morning. Thanks for taking my call. David, I've got a VCAT case coming up on the 5th of October. I've been waiting a year. Basically, I bought a car brand new in 2017, and within 5 years of ownership, it's cost me just under $20,000 in repairs that weren't honoured under warranty. Do I need to keep the car to go to VCAT? Because, that's the question. Really.
Not the way you framed the question, Tom. Your argument was that these repairs were done, that they ought to have been a warranty claim. Warranty was denied and you paid for it. So, you don't need to have the car to pursue the claim. But, the problem is, I presume you've got evidence that indicates or vindicates the position you're taking?
Yes, absolutely. I've got engineer reports of both separate problems.
Okay. Then the answer would be no, you don't need to still own the car because your claim is not for the loss in value of the car. Your claim is I've paid X dollars for repairs that I should not have had to pay for.
Well, actually, I am asking for a refund on the car as well because I can't sell it.
Sorry. But do you still own the car or don't you?
I own the car.
Okay.
I have it.
Yep.
Yeah, I put it up for sale, but I'm just wondering, because I do want to try and get a refund on the car, do you still need it for the hearing?
I would keep it. I just think because then it becomes an issue as to what it's worth when you dispose of it. If you've still got it, hopefully there will be a requirement that you hand the car back and they give you Y dollars.
Wow, okay. All right, great.
Right? Okay.
Hey, Tom, how do you feel every time you look at the car?
Disgusted, to be honest.
Okay.
Yeah, it's really bad. It was off the road for 6 months. It was we were planning to do a trip around Australia and stuff, and we couldn't do it.
Well, thank you for your call anyway. Let's go to Christine, who's at Malvern. Hi, Christine.
Hi, Warwick. Hi, David. Thanks for taking my call. Okay, now I have an issue with road rage, and I need my question to David is basically
have
whether...
you mellowed, Christine?
I'm sorry?
Oh, it wasn't you with road rage. It was someone else, was it?
Oh, it was somebody. Yeah, I
Okay.
was a victim.
Yep.
I was the victim. Basically, I just bipped at somebody who was pulling out just to say hello, I'm here. So that was okay. I went past. It was a one-way street. He came charging down the one-way street behind me. He hit my car from behind as I was waiting to turn right. And then so I checked my car, saw there was damage, drove around looking for him, found him parked in the street. He saw me coming, walked up to my car. I had the window down, yelling and screaming and pointing and spitting and all sorts of things. And then...
Christine, you can report that you've got to understand that criminal charges don't belong to you. They start with you, but they don't belong to you.
Okay.
So what happens is that you make a report to the police. But
I've done that.
But it's ultimately the police who decide whether or not criminal charges will be pursued. It is possible for you to bring a civil action for assault. I don't recommend that you do. I think that's putting an awful lot of effort into something that's not going to give you a return.
Sure, yeah. No, I wouldn't be. That's fine. But my question really is about my report to the police. I mean, it's about it's about the report to the police. I went to the police and gave them all the details. I had a witness as well. So weeks later, I was still waiting I thought they would immediately do this. So I was rather, it's not in the real world. And a week later, they can't give any time frame as to when they'll be speaking.
Christine, I got a call from somebody one day who actually on the radio, who really wanted to know why a complaint to the police hadn't been actually made. But if you sit down and crunch some numbers, there's roughly 20,000 police in Victoria. When you look at the size of our population, you look at the workload of police, and on my calculations, there is a police officer on duty in Victoria at any time for each 2,000 Victorians. Right? Now, it's not... If you actually crunch the numbers, there's a lot more police per 1,000 in population than that, but they don't work 24/7. And so on my rough numbers, it's 1,800 to 2,000 people are protected by a police officer at any one time. And so what they have to do is work out where, in the great scheme of things, they rank Christine's complaint.
Christine, I hope that helps at least clear things up for you. 1300 222 774. If you have a legal question for David Whiting, it's 10:20 here on ABC Radio Melbourne. And Jenny is on the line from Caulfield. Hi, Jenny.
Hi, Warwick. Hi, David. Thanks for taking my call. I'm on an owners corporation. We've got 10 members. We had a general meeting in January and only 3 people attended. We elected a chair and I was elected the secondary contact. 2 of the committee members come from the same unit, the chair and the other committee member. We made decisions, we circulated minutes and all of that sort of thing.
And then they become preliminary decisions unless a time elapses, in which case they become final. Yep.
Yeah, so we've been acting, and the way we've been doing it is the chair sends out an email to everyone and says we're going to get a OH&S report, and if anyone objects, to let him know within 2 weeks. But now we're not certain whether we're properly constituted under the amendments to the legislation which took effect in December last year. Because they say that you've got to have, if you've got more than 10 or more members, you've got to have at least 3 committee members and not more from...
co-owners of the one unit.
Yes.
Jenny, listen next week and I'll tell you. No crisis between now and then. The question is, in counting those numbers, do we count joint owners of one property as a person or do we count them as individuals? I'll let you know.
Oh, that would be great, David, because our Owners Corporation manager has actually said we can continue to act the way we have been, but now we're sort of sending everything out through the manager and it's going by ballot and it's we're not getting anything done.
And it's going to be very expensive and nothing's happening. Jenny, next week.
Next week. Homework. We got you homework, David.
Yeah, you did.
Yes.
You shouldn't be proud.
Oh, I am. Don't worry about that. Louise is at Glen Waverley. Louise, welcome. You're talking with David Whiting.
Oh, good morning. Thanks so much. My query is about, is there some way of hurrying up an executor? We're coming up to the second anniversary of my aunt's death.
Yes.
The superficial stuff from her unit has been divided and gone to everyone. So all that's left to do is to get an estate clearance company in to get rid of the last household items and put the unit on the market. And nothing is happening.
So let me confess, I currently have 2 estates for people who died in 2015. I got 1 estate from 2015 that isn't yet finished and probably won't be till next year. And I have 1 estate from 2019 that I should finish up this year, right? But that's still a lot longer than usual. We also finished an estate this year within 4 months. So it kind of depends what's there. Yes, it's taken too long. You need to... Is the executor given a reason for the delay?
No, and we've had a very good working relationship. Like before my aunt died, I was the carer, but he did all the legal and financial stuff. So we're on very good terms. He's hopeless at answering emails and stuff, but, you know, all our interactions have been very cordial and great. And in my mind, if I was the executor, I'd call an estate clearance company today, get that done, tear up the carpet, polish the floorboards, put that unit on the market, and I'm seeing house prices going down. And
I am too.
Thinking, well, for goodness sake, what, how difficult is it to make a phone call? And
well, I think you need to put some pressure on the executor, Louise. I would be going along and saying the property's now worth less than it was when she died. The law gives the executor a year from date of death. And you really don't have grounds for complaining in the first 12 months, but after that you do. So I would be suggesting a meeting between the executor and the beneficiaries to resolve it.
Louise, I hope that helps. 1300 222 774. Jeff's in Bendigo. You've got a call if you want to get through. Don't bother sending a text at least for the next few minutes. 1300 222 774. Hi, Jeff.
Yeah, g'day, David. We've had a property settlement recently and the conveyancer that we used made a $1,200 overpayment to a third party. And now they're ignoring responsibility for that. We didn't get to see a statement of adjustments prior to settlement.
So what was the nature of the overpayment? Was it a payment made to a council when you'd already paid the rates?
It was actually, we sold a leasehold, and it was to the leaseholder for fees for the establishment.
Then my thoughts are that it's your conveyancer's responsibility to properly account for your share of the proceeds.
Okay,
so I think you have a claim against the conveyancer for your loss. The conveyancer has a claim against the person who got the $1,200. But given that you didn't specifically authorise the payment, but relied upon the conveyancer to give effect to your decisions, it's the conveyancer's issue, not yours.
Okay, so we've spoken to the conveyancers industry group representative.
Yes. And
our requests for recompense and making us whole are being ignored. Where do we go from here?
Well, it's either the Magistrates Court or VCAT.
Oh, VCAT's probably the...
I would go to VCAT. Cost you a lot less. Take you a bit longer, but it will save you some money on the way through.
No worries. Fantastic. Thanks, David.
Thank you very much for that, Jeff. I'm going to have to shelve a lot of the questions until next week when David returns, but keep those questions on hold and we'll work out a way to get them to you. But David, why don't we have some homework for you?
We do. I've got something to do for the rest of the week. Thank you very much.
And just on the point with VCAT, just before I go quickly to Marcus Padley, but in terms of hold-ups, and we were talking about it earlier in the wheels of justice turning slowly, is it the same in VCAT coming out of COVID?
VCAT, when COVID started, VCAT was an entirely paper-based system. They've spent an incredible amount of time computerising and dealing with their backlog, but then there are issues in relation to priorities. They're simply saying they took the view that compensation claims and tenancy disputes, people getting in and out of tenancies and getting their bonds back and the rest of it, was a priority. So, and also guardianship issues. So, in a sense, some lists had to be processed slower so that looking after people, as opposed to simply dealing with mere money events, needed some priority. And I know they're dealing those backlogs are significantly lower than they were.
David Whiting, good to talk to you. David Whiting there with Legal Talkback.